2025, 5 p.m. Before we go off into the meeting, I would like to everyone to bow their head for the children, the parents, the teachers of Antioch High School. Amen. Thank you. We would like to call this meeting to order and to say that we have a quorum. Okay, we have a quorum. All right. We'll have the reading of the appeal statement, Attorney Clark.
Pursuant to the provisions of Section 2.68.030 of the Metropolitan Code of Laws, please take notice that decisions of the Metropolitan Government of Nashville and Davidson County Community Review Board may be appealed to the Chancery Court of Davidson County for review under a common law writ of certiorari. Any appeal must be filed within 60 days after entry of a final decision by the board. Any person or other entity considering an appeal should consult with an attorney to ensure that time and procedural requirements are met.
Okay. All right, approving of the minutes. Like everybody had the opportunity to review the minutes. Okay, can I get a motion to approve?
Just 1 second. I did send out an updated version, so all we did on that one was pretty much change the format a little bit, so there wasn't any real changes to it.
Okay. Can we get approval with the necessary correction?
You need a motion?
We need a motion?
Motion
Yes,
to approve.
Second. Okay, it's been properly approved and second. All right. On the agenda, we will go down here with the chair remarks, and whichever will be me. This is the beginning of 2025, and this is our first meeting of this year, and I'm proud to say that to see as many people attending the board meeting. It's my first official meeting as chair, and we small in number, but we mighty, and so we work together. We can accomplish many things. I've seen some ideas where we're doing some community projects, which is great, to let the community know that we exist and we are for them. We're the eyes and the ears, to assist them and to helping them with whatever complaint they have. And a lot of people are not able to front issues that are fronting them out into the being stopped by the police. And so we're here for them, and hopefully that we can get some of these complaints resolved at each meeting. Depends on how we receive the information. Okay, that's it for my comments on that. Do we have any public comments?
No, not today.
Not today?
Not yet.
Not yet. Okay, well, can we get our attorney clerk to read that statement?
Thank you, Chair Holloway. Pursuant to TCA 844-1, a period for public comment is reserved to provide the public with the opportunity to comment on matters that are germane to the items on the agenda. Each speaker is allowed up to 2 minutes to speak. Speakers may register in advance by signing up on the public comment sheet located at the entrance to the meeting room.
Okay, thank you, sir. Executive Director report.
Thank you. I don't have a physical report, but I will get you one. I have been on vacation but I do have some updates. So I will send you out a report with these updates as well so that you have it for your own personal use. I don't have a lot of updates today. I will say that as it pertains to cases, we had 2 new complaints for 2025. Which is a little less than what we've had in the previous months, but it is winter time, a lot was going on, so that, and then we had a couple that were out of jurisdiction, so we sent those on over to the people that they were supposed to go to. We have a total of 5 now of 2023 cases that we're trying to clean up and get out. I found out today, and we have 71 2024 cases. And so I found out today that the OPA has a total of 10 investigators at the sergeant level. So now all of the OPA investigators are at the sergeant level. So, and they have 10. And we have been getting cases back pretty quickly. It's been a quicker turnaround. We've been getting a few a week of closed cases, so that's good. But of course, with only 3 investigators, it keeps us kind of behind the 8 ball. So we need to talk about that in our budget talks this particular budget season. Of course, you all knew about the MLK March, and I appreciate all of you all who were able to attend and support in that way. We have some training scheduled for this month for the staff, and Mr. Nguyen has so thoughtfully asked if he could participate in a training, and so we are going to try to get some dates together for that. We have we have been in contact with the Tennessee Bureau of Investigation as well. We're trying to get that meeting scheduled. But we have that meeting scheduled, I'm sorry. And that's pretty much all that I think is important as it pertains to updates currently.
Okay, thank you.
Oh, I'm sorry, one other one with the sexual misconduct report. I did reach out to Ms. Hall from the Human Resources Department, and it looks like they will have some answers for us before the middle of February is what they said. And so I also ran into her out, and so they are working diligently to get that resolved. I think it's really important that we move forward with that, especially as we are moving these cases forward that have some undertones of I wouldn't say necessarily sexual misconduct, but some things that need to be dealt with. And so it's important that, as I stress again, that sexual misconduct report, that policy advisory report is implemented as quickly as possible. I think it's important, and you'll see as we go along in these cases that we have, that we'll be presenting, that have some either sexual misconduct or some undertones of how things should be done, or they're not done, I would think, in the most efficient and proper way when people are making these types of allegations.
It's important that we can get everybody on board with this sexual misconduct. We've seen past where people have gone through that process with some of the rank and file people and then non-rank and file people. But the fear of losing their job and not complaining about it, makes a big difference. So we got something in writing that will protect them from being retaliated against. And so it's most important. I'm seeing many lawsuits that have been settled last year where industry had paid out a large sum of money due to the fact of sexual harassment. And the main thing is people are being protected and they don't have the fear to go through that process, so thank you for that. Next thing is on, you have a question? Go ahead.
I think something was wrong with my microphone.
Okay.
And so, thank you for that verbal report, Edie Pitcher. What are we meeting with the TBI for?
in regards to an MOU agreement.
So we'll have a separate MOU agreement with the TBI.
I don't know if we will have it, but we're gonna have a discussion.
Okay.
It was-
That's what we're going for.
Yeah.
That's what we're gonna ask for. And have we spoken with, DA Funk?
You wanna answer that? Have you gotten in touch with him?
Not lately. That remains in progress, and that's something we'll be also hopefully making more progress on before the next meeting.
Okay. So we do want to have a separate MOU with the Attorney General's office, with General
With
Fund.
the district attorney.
District attorney, right.
Yes, I spoke with him, I want to say it was November. I saw him
Mm-hmm.
somewhere and gave him I gave him Frank's number. He told me to text it to him, and I did. And so I was under the, assumption that they were going to have a conversation.
Mm-hmm.
But I haven't heard of any updates except for what Wesley just gave, what he's been giving me. So
Okay.
I think that, we do just need to try to set up a meeting with him.
So we have a meeting with the TBI before we have a meeting with our own general. Okay. That's great. And, just to be clear, OPA has 10 investigators
10 sergeant level investigators, yes.
to our
We have 4 total.
4. Okay. And then, one more question, Chair. The zero tolerance sexual misconduct. The zero tolerance sexual misconduct policy that was supposed to be completed at the top of the year, which would have been January. Do we know why it has been delayed?
Yeah, I can tell you here what she says about that. She says, we made a recommendation about sexual misconduct, and we used the terms throughout the report. She said we described various forms of sexual misconduct, including harassment, discrimination, direct sexual contact, which is consensual or non-consensual, sexual assault, law enforcement functions, investigating criminal sexual acts, assaults, etc. And because some of those languages, I think, are protected under like Title VI and things of that nature, it says it was requested that Metro Human Resources review this report in comparison with Metro Civil Service and employment provisions, which are governed and defined by local, state, and federal provisions. Metro's employment provisions and the legal purview of Metro Human Resources are more limited in scope and applicability than what is outlined in this report. And as a result, there are portions of the NCRB report that are not applicable or cannot be addressed in their review. And so Metro Human Resources, in reviewing the NCRB report, and where applicable, try to identify any gaps between existing employment provisions and evaluate recommendations to strengthen Metro's sexual harassment prevention and non-discrimination provisions as allowed by local, state, and federal law. And then she's asking that we give them, they thanks us for the support and the patience as they try to come together to complete everything and make certain that it lines up with the legalities that are attached.
So it was, she's searching for gaps. We're using different language. Was there any conversation in that correspondence in terms of how the community is involved in the sexual, zero tolerance sexual misconduct policy that we presented? Because I don't know how that would fare with human resources and how we have this sexual misconduct policy that not only involves employees, but also involves community members. Do you get what I'm saying? Because
I'm trying to.
Okay, so the policy that we submitted, right, is not just focused on employees, but also
That's correct.
community,
community.
right? The community.
Right.
Where did she mention anything about the gaps that she may find because it has something to do with the community and not just Metro employees?
No, I think that this is strictly towards how it fits in with other Metro departments and not, so what you're saying specifically is that this report not only covers the protection of employees.
That's right.
But it's also how officers interact with civilians.
Correct.
And citizens. And so that part is not, included in here, but, I think that in general, that would be policy change in general, just for the
Correct.
police department and how they conduct their work. It's not included on how, if they are, there's an alleged act of misconduct, is what you're referring to.
And so that's why I want Attorney Clark and Mark, if you could chime in, because we know we have the analysis that's being provided by Human Resources that pertains to sexual misconduct in terms of employees. But what do we do with the portion of the policy that has everything to do with community members who will come into contact with police officers if there is a sexual assault or some kind of issue, with civilians? What are we doing with that? I know we're not gonna throw that part out because it doesn't pertain to Metro employees. So how do we handle that in terms of making sure that's included or a policy update as it pertains to MNPD?
So is that addressed just to me? Thank you. So I had a couple of questions, and you've answered them, some of them already, is why HR is reviewing policy for police procedure. And I completely understand if they're looking at the overall responsibility of HR to make sure that workplace is safe and there's not sexual harassment going on. The sexual misconduct policy is something different. We're talking about a focus and a priority on sexual crimes being committed by people of authority, whoever they are, with a gun or badge, right? So I'm holding off on my judgment. We don't know all the details yet of this, but I want to just put this out there as a warning for us as a board that very often when you do policy development, you have to ask who's part of that development process. The bigger the scope, attorneys, community leaders, sex crimes investigators, churches, whoever it might be, you want the broadest view to make sure that it covers everything possible. But often what happens when policies are reviewed, it's looked at as, well, let's pull a piece of this out and supplement our existing policy. If we do that, then you've taken away the power of the priority of a standalone. That's police language. Standalone policy, like a standalone policy on deadly force or standalone policy on high-speed pursuit, because these are really important issues that have to be addressed. And if you take pieces of the policy and mix them into what's existing, then you're not, the message is being conveyed. This is just an amendment. This is not that big a deal. And this is a major problem for policing nationwide. And we don't know the extent of it. If there's any in Metro, we don't know that. But that's what policy's for. So I'm concerned that if HR needs to be, if they have any questions, that I hope they reach out to the proper folks who do this work, and I can be more than happy to direct them to the national authorities on this if they have questions about the legalities of it, because everything that we've submitted has been absolutely, positively okayed by the Department of Justice, that they paid for it, including the Civil Rights Division of Justice. So I hope, that when they review this, they understand that this is not just a board in a city who got together and decided to make up a protocol on sexual misconduct by police. So I don't know the answer to that. It's going to be up to Chief Drake and his staff to accept it once HR looks at it. But I'm worried that it's taken a long time, and I hope that nothing's lost in the urgency with HR. So that's my only comment on it.
Let me say this.
Yes.
It can be included in the policy, but really they got a departmental policy of your conduct, how you should act with the public. And if it's a situation where it might be criminal, then they'll turn it over to a special investigation that investigate these sexual charges and see where they go from there. And hopefully it's not criminal, but if it is, they can prove that, hands-on and was unwanted, then the police department have to do what they have to do and do the charges of put on lead until the investigation is over with, because it could lead into something much further as far as a lawsuit, saying that I was misused or mistreated sexually by the police department, and they start at the top and file a lawsuit and go all the way down to the bottom. So you try to catch the beginning process of it, and if you don't, it could go much higher, much in a larger lawsuit, So it's best to investigate it in the beginning process, and the sexual harassment policy is a good policy, a good tool that educate and make people aware that we are serious and the public are serious, and we must be professional.
If I may, thank you, Member Haddock. What I see as a really appropriate place for progress here with both HR and what they're identifying as like their little silo of particular concern, and then also helping really MNPD with an issue that, as Member Wynn identified, is emerging and is well known and is something that I have personally litigated over. Are situations where it's not so black and white in terms of, yes, this was a forcible sexual encounter that someone didn't consent to. It's more a question of, well, was there really the ability for someone to consent when there's this power dynamic and between a person in authority and another person who is not in authority, whether that's another employee, whether that's a member of the public, and those power dynamics will, experts will tell you that they are so significant, especially in professional contexts or in certain areas where, it's easy to see it in a inmate-guard relationship, that even though an inmate may be going along with it, they really don't have the mental, capacity in that situation because of the authority dynamic to give valid consent. And I think perhaps if we were to approach Chief Drake to say, hey, this is a really good opportunity for us to work together to ensure the department is establishing policies in this subject matter area that would both, prevent liability and also create an environment that fosters the highest standards of professionalism. It seems like that should be a win-win for everybody involved. So perhaps we could focus on sort of filling in the gaps where criminal law doesn't apply and where HR doesn't apply. There's a big area for misconduct and liability there that the board's proposal could help with. So I think that's something that could be pursued.
Let me agree with you about the consensual part. This is the part of why this is so specific, because of the authority that they have, just being their presence in a room is authority funded by the taxpayers. So it's pretty clear, if fear's in the room, consent's not there. So this is something that for public service workers makes it much more important to state clearly how we feel about any kind of sexual misconduct with someone who's using our authority that we've given them as a police officer. So I agree with you.
And I just want to add to that what we are presenting to the public are cases that involve the public. These are not cases that involve employees who have made a complaint. And so as you will see in the cases that we have, it's not necessarily that an officer that was involved in the sexual misconduct, is how they handled the allegation, how they handled the alleged victim in the case. And I believe that as we move into these cases that we have where complainants are involved, that we will see the necessity of having a strong sexual misconduct policy in place. And my prayer is that it's done as a standalone policy, because it's just that important.
And I would say, going off of the cases that, we'll hear this evening, that we do this simultaneously, meaning make contact with Chief Drake. If we anticipate receiving Shannon Hall's, the Director Hall's, analysis or report by mid-February, and we believe that she probably, this gap that Attorney Clark identified, that she may not address that, then we may want to go ahead and reach out to Chief Drake and his staff in terms of how we ensure that that need is being met. And you said prayerfully, we would have a standalone policy, but what is going to be the actual remedy for a policy that is supposed to be metro-wide? But we know if it is metro-wide, then it could leave a huge piece that doesn't apply. And we have to ensure that the public is covered in this as well. Does that make sense to everybody? Chair, could you, I had just recommended that we reach out to Chief Drake.
Yeah, it'd be a good thing to do. Chief Drake is a very noble person, and it doesn't seem like that he cooperate with you, but he will. I've known him from a very long time. Remember when he first came on the department, and the police department period don't like changes, but they know that if this is something that coming in the future, they will adjust, and I believe we continue to run the course that we will get some good support from the police department. Are there any more comments from that? Okay, if not, give me if you're gonna talk, you got a green pal. Work with me. This is my first day as chair, and if I don't see you, I try to look both ways, but we're gonna all get along here today. Okay, what's that next thing? Board committees. I have a printout of the different boards, like the Rules and Bylaws Committee. You got Joe Brown, Walter Holloway, and Sean Whistle. MOU Committee, we had somebody that left, I think. We got Alicia Haddock. Nomination Committee, Walter Holloway. Training and Education Committee, we got one vacant, and then Mark Wynn. Budget Committee, we got Alicia Haddock. Communication and Outreach, we have Alicia Haddock and Sean Whistle. If anybody decide they want to join some of these committees, please let me know. We don't have 11 people. We were reduced to 7. So sometimes we have to double up on something. And then sometimes your work schedule won't permit you to be on more than one committee, But whatever time you give us, we appreciate it, because we're doing it from the goodness of our heart and then in the support of the community. Okay, and
Is there there's an expectation for every board member to serve on a committee? Is that correct? Yeah. Okay.
And I just want to add, like, if you want to keep these 6 standing board committees, then you can. But if you want to reduce them, maybe. But if not, because I think we had more than that initially, I believe.
yeah, I think.
But I think maybe communications and outreach. They sound good to me.
Some of these,
MOU could be a task force.
some of these committees will be working full time, and some just like a temporary period. We got some people that's not here may want to join some of these committees, so we're not trying to eliminate anybody. Mark, you have a question?
Thank you, Chair. The MOU Committee, I'm more than happy to serve on. I think Judge Brown is on the, is that right?
Yes.
I don't mind working with him. He seemed like a pretty good guy.
Okay,
Okay, so we got Mark Wynn and Alicia Haddock on the MOU committee.
okay. I was just looking at, the rules and bylaws. You guys good with that, the way that it is? Okay. MOU, we've got Joe Brown and Mark Wynn and Alicia Haddock. Nominations, just, you want someone on yours, Walter? I mean,
Yeah,
with the
but
nominations?
I don't want to make the decision tonight.
Okay,
And I have a reason for that.
okay,
I want somebody that's gonna be very supportive and willing to work. The nomination committee is a very strong committee, whether you know it or
oh,
not.
yeah.
And my thing is, get me into the next meeting and I'll have you somebody to be on that committee. But I don't want to pressure anyone, to do this. But like I said, we're small in number, but we got to work together.
Well, I think that as we look at these six, there's only 7 people. We have multiple people on these committees, and that's a lot of work. And so if everyone would kind of like think about what committee you want to serve on to kind of adjust the weight, that would be good. And if you think that there's a committee that could be a task force instead, I think that these are these are basic ones. But if we needed to change one, then, we could do that. But I think this is fine if you want to be on it. I mean, really, the rules and bylaws only meets probably when we need an update, right? It's not like we're meeting monthly, and same thing with budget. Budget, we might meet a little more in the next, but not as, But training, education, mediation, communications and outreach, yeah, those are the busy ones that we need as much help as we can get. Go ahead.
And I would also note, Judge Brown mentioned before that, you'd like to have 2 people at least on the committee, and then more is better. And we have 1 more for the MOU committee, so if any other board members are available for a Wednesday, February 5th, meeting at TVI headquarters, I would say, that's a sign that you should probably join the MOU committee right here, right now. But that's my legal advice.
Thank you. All right, next here. Okay, the resolution for officer involved shooting. No, okay, excuse me, got the F, we got the budget committee. You ready for that,
Yeah, you want to give an update on it? Like, Member Haddock.
Yes, we are working through the budget, and so we'll have a meeting. Our next meeting is going to be Wednesday, this coming Wednesday at 1:00 to finish the budget discussions as well as get it prepared for the budget system and for us to present it to the board for a special call meeting so the board can vote on the budget. I do want to note a few things that I would like for us to think about as we are prepared to look at this budget as a board. And that is really the specific note that Director Fisher mentioned in her report in terms of sergeant level investigators and OPA versus the number of compliance monitors that we have in the Community Review Board position. And so that really puts us at a deficit in terms of the workload when we're receiving information from their investigators and OPA, and then the limited number of compliance monitors that we have on the review board's staff, because that in turn puts us behind because we're only working with 4 to someone's 10, and when we're getting those reports, that puts us behind in the work. So the question is, do we want to continue to, thinking of it in terms of the budget, work at a deficit as we did at the COB when we only had a limited number of investigators, and do the same as the Community Review Board? I would say no, and I would really want us to be prepared to think about an increase in compliance monitors and additional staff as we look at the increase in population in Nashville, but then also we have a new precinct. I don't know who the commander will be in South, okay. But we have a new precinct coming online within the next year, right, Commander Laura? And so our calls are increasing in the Antioch area. We need to be prepared for an increase, and hopefully we won't have an increase in workload, but let's be realistic. We need to be prepared for that, and we need to talk about that, and that preparation needs to be reflected within the budget. So I say that to say, when you all receive this and we have to vote on the budget, that we already be prepared in recognizing those gaps being filled when we present them. Any questions?
Well said, but we have already talked with the director about it, getting additional people to her staff because of the workload.
Mm-hmm.
And I also advised her, if you don't ask, you won't get.
Okay.
And if I'm incorrect, there she is right there, she can talk to you about it. So,
I already talked to her too.
yeah, so that's what we've been talking about. We always said at the executive board meeting. And so we're all on the same page, so staff need to be increasing. And in order to increase the staff, you need to increase the budget.
Thank you.
And I just wanted to add that this budget that we're turning in it goes along with the mayor's budget. It's not the one that goes before the council right away. So we're making this ask to the mayor's office, and then they make the decision, and then we then have to work with the council and the budget the budget committee in order to, if in fact there's something that we didn't get in that mayor's, whatever the mayor proposes.
So if we have something that if we are doing this to be included in the mayor's proposal, what if the mayor's proposal isn't chosen or accepted by council and it's someone else's, the budget chairs? Mm-hmm. Is that?
So that process is,
to do with it?
you put your budget in, like we said, we're gonna have to update this system on the 7th, which is next Friday. And so that's why we're voting on a budget on Monday. That is what we're proposing, that the CRB wants for this budget cycle. The mayor gets that information, I guess they review it and make their decisions for all the departments. And then that goes to the council. And when it goes to the council, then that's the opportunity that we have to present in front of, however it could be different, whether they want us to present, whether they want us to send them information. Every year, it's depending on who the budget committee chair is for the council on how they want to proceed. I think last year, you would ask to be heard, and you would go in front of the council and tell them what your needs are. And if that's the way they're doing it this year, if we don't get what we want in the mayor's proposal, then we would go in front of the council to ask for whatever it is that we didn't receive.
Thank you. So should we anticipate this special called meeting on the 3rd of February for the budget approval?
Yes, we sent that around. We have set that up for Monday the 3rd.
Oh, I didn't see that.
It's at 5:00 at this time, and it's just, it's a one agenda item meeting. And that is for you to vote on whatever budget that we're going to send to you with all of the support documents.
Thank you.
Board Member Wayne.
Yeah, I had a couple of questions, and forgive me if you've already done this, Director Fitchett. There's a difference, I think, in the job work for our investigators and the department's investigators. They go to court, they go to jail with defendants. That takes a lot of time. But the casework is similar in a lot of ways. So my question is your expectations of the investigators. I mean, for case management purposes, they understand what you expect. So have you done basic task analysis for cases assigned, cases completed, time span of completion of those cases. So if someone were to ask, we say, look, we're not sitting around drinking coffee. We're working cases, and we'd like more time to more in-depth investigations if we had more investigators. Is that something that you've
Yes,
done with your staff?
we are tracking our time spent on each case. We have our data and our research team tracking that information for us. So how many hours that we've spent reviewing information. The problem that we, have, just to be like really frank, is, the wait that we had. So much so that we have over 70 cases just waiting to get documentation, and then going back and forth with them about the documentation has taken much longer, where they can finish and complete a case much sooner because they have direct, unfettered access to the records. And we're having to go through step by step to get records. And even so, today I was talking to the commander, because we're trying to build this relationship in regards to what about the cases. If I start doing our backload from a chronological perspective, right, starting giving you 2023 cases first, like alongside some 2025 cases or 2024, but I really want to start at the top, of the cases that are the oldest. And I was like, well, what about this information that I may need other information, like the records may not, the body worn camera may be not what I need, or it may be redacted in a way. And, the conversation was, like, well, I don't know, because I don't know if we can go back from the MOU, because you didn't have an MOU in place. And, my stand will always be that we had access to those records from the moment the law was written, because that's what the law says. And so that is a holdup if we have to go back and then ask for more time. And so I think that your question is, can we, how many people do we need? I think it should be parity. I really do. I mean, because when you're looking at this case, it took me hours to review the evidence and then document everything, and then create this formal document for you all. And so, with three people doing this, it's just, we're never going to be in my opinion, it doesn't seem like we'll meet our own goals. Okay.
One more thing. So with OPA, they're investigating other things that we wouldn't investigate, right? So there are other caseloads that they have.
I'm sure.
So what would the comparison be? I mean, do we know the OPA's caseload and expected turnaround on every individual case?
No, not yet. I know they get 45. They have a 45-day. That's in their policy. But as for how many that's a question that I did talk to Chair Haddock about a while ago. Like, I have no idea how many cases that OPA has, how many cases that they get directly from the public, or if they're doing cases from the precincts. And so I think that is information that we should have access to, that we don't have access to. And so I'm glad you brought that up, so I can make that request first thing in the morning.
So we don't know how many complaints are filed against the police department by the public?
No, we don't have that information.
No, not if it's coming from elsewhere and not the CRB.
They
And it comes in how many different ways? It comes at a precinct level. It could be filed in Metro HR, the MNPD HR, MHRC. So it's a number of avenues that complaints could be filed, and we don't have access to where those complaints live, where they are, how many they are. So we still have work to do in terms of the access we have
And
that was given by state law.
That's not confidential information. Those
It's
are
not.
the numbers.
It should be given to us.
One more last thing, and
Okay.
I promise we move on. So what you're saying then is that because the rules have changed and the law changed the oversight responsibilities, it's made your casework longer? Is that what I'm hearing you say?
And I would even say more elusive, but go ahead.
Well, yeah, I think so, because from 2023 until when did we sign the MOU in November? we were barely getting anything on these cases. I mean, we still have cases that they didn't send us, they haven't closed out, and those cases have been open for 8 to 10 to 12 months, which is outside of their 45-day rule, without any explanations. And their thought process is what I heard, from my perspective, was that anything prior to the MOU, we would need to go to Metro Legal to get, or go through legal to find out what we could do about that. But, okay.
Board Member Heather.
Thank you. I just want to make sure I heard you correctly. I understand there are different mechanisms for people to file complaints through the different avenues that you discussed. Did you ask if there are cases that OPA they're reviewing that we are not reviewing? And forgive my ignorance, I know I'm new to this board, I've got a lot to learn. What would those cases be?
Well, any kind of disciplinary action inside the agency, from like a sergeant to an officer level or lieutenant to
they're
a sergeant
internal.
level. So there's a whole range of things that they would administratively deal with that we wouldn't necessarily see because they're not a complaint.
Those aren't
They're
civilian.
internal matters, not external matters.
Okay, thank you.
Right, but even the cases where they have, for instance, if I'm a civilian and I go to OPA directly, I don't use our service. There's nothing that tells me that OPA received 15 complaints from civilians the month of January. And that's what we need to know. And that's what we don't know, that and maybe, we asked a long time ago, we haven't updated, but I think that is something that we need to continue to ask, and we need the data around it.
Yeah, I have one more follow-up. Thank you, Chair. So just to be clear, these cases that we're unaware of that OPA may be reviewing, we have the statutory authority to review every case that's a civilian complaint, no matter who it comes through, correct? So we just don't know how many
Right,
there are.
we've been focused on the ones that have been filed with us strictly.
Okay.
Yeah. But we still should know how many cases they have that are civilian led in their agency.
Basically, what they're going to, we're looking at are the numbers. How many cases come in, how much time, and how many cases you had to send back, and then you say you've gotten cases that is out of your jurisdiction. You have to include them in your time work, because it take time out to go through cases that are not in your jurisdiction. You could be doing something else instead of dealing with that. And that has to be included. That take away time. So, in other words, you could compare the past year with the year before and see how things are picking up, how much the workload is increasing. This would explain why we are spending more time trying to resolve these many number of cases as opposed to last year. So if we did twice as much work, then we need additional personnel to be able to keep up the workload. Any more questions? Mark, go ahead.
One last thing, I keep going, promising something, I don't do it. But NACO, I'd be interested to see what NACO considers an average case time for an individual. I know it's not fair to try to put this in a frame, because each one of these cases is completely different. I understand that. Some take longer, some take shorter. But on average, what does NACO consider reasonable amount of time for oversight investigator to review a police case and come back with a decision?
Well, I'll tell you that most of the agencies, they have 6 months. Not most, some that we've had these conversations when we go to NACO and just in our investigator roundtables that they have. A lot of agencies, and I don't know why the 6 months, I think 6 months is a long time depending on what type of cases they are. I know with officer-involved shooting, some of them have full investigatory authority, and then trying to get records. I think that the issue has always been the ability to get all of the information unless there's been some kind of consent decree in place. So other cities have way more, officer-involved shootings, like Chicago or New York City. And so I do know that they have about 6 months, anywhere from, 4 to 6 months to complete an investigation. And that's if they have everything that they need. And so I think hopefully, ours is 90 days within our MOU agreement, and evaluating, even just, I haven't documented the hours that I evaluated these cases, but it was hours of time.
Commander Laura wants to come up.
Commander Laura?
There we go. Happy New Year, first of all. I don't think I've seen you since last year, so hope everybody's doing well. I just want to clear up a little bit of the timeline. So I know one of the things that there's always confusion is how long it takes for us to finish a case. So we have a 45-day window to complete these cases, but that actually begins from the moment that the officer is given the notice of complaint. Many times what will happen is we will get, I worked at OPA for some time. You'll get a case, a complaint, and you will actually do a lot of preliminary work. And sometimes that preliminary work will take months and months and months to try to get as much information as you can before the officer even knows that the case is going on. And so sometimes when you look at the timelines, you go, wait, and this took 7 months, 8 months, a year to complete this. Many times the first 8 months may be, or the first 9 months may be preliminary work where we're trying to actually gain information that may be relevant to the case, that if we don't get it right away or it takes us some time, we don't want the officer to know until it's, we have the information. Then we'll bring him in and we'll start the 45 days where we'll actually take the information that we have and we will do the investigation, interviewing the officer, interviewing witnesses. But again, many times that information that we need, we have to get it before the 45 days, before the officer is notified of the complaint. And so sometimes, again, when you look at these timelines, you're going, man, that took a long time, but it's not necessarily outside of the timeline because it's preliminary information we're getting. Once we're serving the officer with the notice of complaint, then that 45-day begins. I hope that kind of clears up a little bit of the confusion.
Mr.
We'll buy that. Please, we'll let you know that. But we're willing to work with you, and I'm sure y'all willing to work with us. Thank you.
Mr.
Wilson?
So is there any type of parameters on that time of that preliminary work? So can it just go on forever? Or is there like a certain amount of time that it has to be done before the 45 days?
So I believe that's it's case by case. We've had a case where officers were, doing things that they ended up getting arrested for and prosecuted federally for. Those took months to a year before we even got to them, because a lot of times these cases, especially the ones that take a lot of time before we give them the notice of complaint, sometimes they're criminal. And so we got to make sure that not only are we dealing with the internal investigation, we may have got a complaint and go, man, this is a criminal, criminal complaint. Then we start to investigate it criminally before we even start investigating it administratively. So that may also take time. So you may go through the whole criminal investigation. Then once the criminal investigation is over, then you start the administrative investigation, because the criminal will always come before the administrative. And so again, that may elongate the timeline on there before the 45 days even starts. We've had that happen on several occasions where officers were committing crimes, and this is in the past, where I know maybe 1 or 2 cases they were committing crimes. Our federal partners actually assisted us with those cases. They were arrested. We didn't start the investigation, the administrative investigation, until once the criminal investigation was over, and then you take all that information and then you do it administratively, which again is 45 days. If we need to go outside of that 45 days, we do have to get permission from the chief's office to be able to go outside of those 45 days. But there has to be a really good reason for going outside of 45 days. And it has to, again, you have to have permission from the chief to be able to do that.
Could you give us an example of like what would be a reason to go beyond those 45 days?
So, sometimes you'll have, you're trying to get in touch with, witnesses that are out of town or not available, or, people get sick. We've had officers who are, gone off on military leave, or officers that were involved that, were on FMLA or something like that, and we can't get in touch with them for an extended period of time. So we have to extend it because, they're not going to be able to, go before, the investigators until after they get back. So there's just different reasons, but it's all case by case. Yes, sir.
Thank you.
Yes, sir.
And I guess one of the main reasons is getting witnesses to cooperate. You know, they excited, they mad one minute, then the next minute, a few months later, then they don't want to be bothered with it, you know. So you got to try to keep in touch with them. Are there any more questions? Okay, well, let's move on then. We got some cases to deal with here. We're looking at the resolution for officers involved shooting. Okay, Director.
Yeah, when we met in our executive committee meeting, there was some consensus around changing the language in the first resolution that was presented with all the whereases and things of that nature. And so I think it is a streamlined resolution that Member Haddock and Member Goddard had talked about in regards to officer-involved shootings. And as you know, while I was away, there was an officer-involved shooting. And so I wanted to point out two things. The first thing is we got very limited information. I wasn't available because, and I know that Commander Lauer did reach out to me, but of course, my phone was out of commission because I was on vacation. But he did at some point, Dr. Kim and Commander Lauer had a conversation about it. Of course, the very next day, which is almost maybe within the same night, the date, like within a short period of time, there was, this other shooting at the Antioch High School. And so what I did, because my conversation when I did check in with my office was very brief, and that is for us to open up our own director-initiated complaint into the officer-involved shooting. And so that is a case that is now a part of the numbers, as it is in our MOU agreement that we can have director-initiated complaints. And so once the case is, because I have very limited information regarding that shooting, just basic information. And so I think that this resolution comes right on time as it pertains to an officer-involved shooting. It seems like for the last few years, we've had an officer-involved shooting every January that I've been on this board. You want to add to anything to it? Okay.
I don't think there's much to add, no.
So this would be just you all voting on this resolution. If you have any questions about it, Wesley can answer those for you.
That's right.
Has all members seen this resolution and read it? Okay. Well, can I get a motion to accept it?
Motion to accept
I
the
second.
minute.
Okay, been properly
Any discussion? Okay.
You had given them all the information they really need, so I didn't think they had any question on that. So let's move on down the line on our agenda here.
If I may, that will be officially resolution number 2025-001. So,
Thank you.
Resolution, okay,
yes.
okay.
And do we have to take an official vote? I know we didn't properly move the second, but I think we need to do all in favor.
Yes.
Yes.
All in favor of the resolution? Please.
Aye.
Any opposed? Okay, the ayes have you. Okay. Now, let's do the NCRB case reviews, starting with, the first one on the agenda is the CC 2023-034.
If I may, I'm going to do these a little out of order just because I'm going to start with the one that has no recommendations first.
Okay, which,
And that is 2024-022.
okay,
All right, and this is a compliance review report, NCRB 2024-022. The allegations of misconduct are courtesy, adherence to policy and rules, and traffic enforcement. The summary of the complaint allegations is that Mr. Ryan Morgan, hereafter referred to as the complainant, reported that on February the 20th, 2024, at approximately 9:15 a.m., he was driving on the shoulder of I-65 South at Trinity Lane when he was pulled over by an officer for traveling in a lane that was not designated for regular traffic. Upon being pulled over, the complainant stated that the officer acted like a jerk. The complainant further alleged that Officer Kelsey issued him a citation. However, the officer failed to provide clear information regarding the cost of the ticket. The complainant further alleges that the officer only asked for his driver's license and did not request his vehicle registration. The complainant felt that he was treated unfairly, that the officer was rude, and that he was being singled out. Policy violations here would be MMPD Manual 4.20.040, G, courtesy, MMPD Manual 4.20.040, personal behavior, A, adherence to policies and rules of the Metropolitan Government, to wit, traffic enforcement. And so, there's a timeline here. I'm not going to go over that for time purposes. And I will say that Dr. Kim, she completed this, and so I'm very happy to have her assist. And that she received the investigative file. It contained the investigation report, the CAD report, and the body-worn cameras for the officer involved, and also the disciplinary file for officer. The findings of fact are on February the 20th at 9:15, the complainant was driving on the shoulder of I-65 at Trinity Lane. He was directed to be pulled over. He was issued a citation for driving on the shoulder. The body-worn camera showed that the officer that did the traffic stop for a vehicle traveling down the strip shoulder. While on his motorcycle, he observed the complainant committing the same infraction and directed him to pull over. So the officer was dealing with someone else, saw this person commit the same infraction and asked that person to pull over as well. The officer issued the complainant the citation, explained the process of how to take care of the ticket in detail. Specifically, he provided several options that you could pay this online, in person, by mail, or by requesting a court date in front of a judge. The officer did not provide information about the cost of the citation. Instead, he referred the complainant to the provided document. There was no evidence to support that the officer acted as a jerk or was discourteous during the traffic stop, and there was no evidence to support that the complainant was treated unfairly by the officer. No mediation was offered. The findings of, the investigative findings by OPA were similar to the things that I just said. Moreover, it says that the complainant asked for clarification as to why he was being pulled over when everyone else is doing it. And the officer stated, just because you see people do it does not make it a lane to drive in. The complainant told the officer no. And then he said, after the citation was written, the officer explained how to satisfy the citation. He went over the 4 options. The complainant asked how much was the citation cost. The officer directed the complainant to review the folded paper in the envelope that was given to the complainant to determine the cost. The officer concluded the traffic stop and the complainant left. The complainant alleges that the officer did not tell him the cost of the citation. The officer provided the envelope with the citation that was written inside the envelope. There was a document that explained the options that the officer went over with the complainant. The officer concluded the traffic stop and the complainant proceeded on his way. In this case, the OPA investigation showed the timeline of events. This is the NCRB's review, In this case, the OPA investigation showed the timeline of events, the body-worn camera, and other available evidence that was used to make the final determination. The investigation was completed by Sergeant Ted Woosley with the Office of Professional Accountability. The review showed that the officer was not in violation of any MMPD policies when he conducted the traffic stop. So the OPA's conclusion and actions were for courtesy. exonerated, as well as for the personal behavior, adherence to policy and rules of the Metropolitan government, to wit, traffic enforcement. The recommendation by OPA was exonerated. The officer, and their conclusion is that the officer was on a traffic stop with an individual for the same violation as the complainant was observed violating. The officer identified a traffic violation, stopped the individual, approached him, obtained his license of the individual, and issued a citation for the violation. NCRB's conclusion is that the assistant director reviewed the evidence in the case and concludes the officer acted in compliance with MMPD policy, and the OPA's investigation is complete and the findings are satisfactory. The assistant director made no recommendations in this case. There was a thorough investigation conducted by Detective Sergeant Woosley into the allegations.
Okay.
Is there any questions for the board? From the board?
Any board member have any questions? No comment? Okay, you've heard the report. Do we get a motion on it?
I have a motion to approve the director's recommendation.
Okay, there's been a motion has been approved and it's been second. Are there any more questions? Okay, now we'll move forward with that one. That's been approved.
Is it approved? Okay, thank you. Okay. The second case is NCRB, the Compliance Review Report, NCRB CC 2023-034. The allegations of misconduct by NCRB, the allegations of misconduct are against Officer Scott Wilson are false or inaccurate statements. The summary of the complaint allegation is that Ms. Shabri Dodson, hereafter referred to as complainant, reported that her juvenile son, age 10, was involved in an altercation at his elementary school on September 15th of 2023 at 3:05 p.m. The complainant stated that her son was attempting to diffuse a situation between other students, and another student grabbed the complainant's son by his shirt and ripped it. Her son reacted in self-defense and was grabbed by a male substitute teacher and put into a chokehold. The complainant states that the MMPD officer, Scott Wilson, hereafter referred to as officer, created an incident report full of inaccuracies, namely that her son was involved in a fight and the substitute teacher was misidentified because his name was spelled incorrectly. The complainant alleges that the result of the incorrect information in the incident report created by the officer was the cause of her case not moving forward with prosecution of the suspect teacher. Policy violations are false or inaccurate statement, MMPD Manual 4.20.050, official obligations, false or inaccurate statements. I'll skip the timeline. Executive Director, evidence review. It shows what was reviewed, which was the OPA investigation report, the CAD report, the body-worn camera for two officers, MMPD incident report, the detective's investigation file, audio interviews with the witnesses, and emails from the school. The findings of fact are such. On September the 15th of 2023 at 3 p.m., the complainant's 10-year-old son was involved in an altercation with another student at his elementary school after the student grabbed and ripped his shirt. Several teachers, including the suspect teacher named in the complaint, were attempting to separate the children. During this time, the suspect teacher grabbed the complainant's son and put him in a chokehold. The complainant's son returned home after school wearing a shirt that she was not familiar with. She asked him why he was wearing a different shirt, and he informed her of the schoolyard incident and being grabbed by the suspect teacher and put in a chokehold. There was no body-worn camera footage of this incident on the playground. The complainant contacted MMPD, and the officers arrived on the scene and spoke to the complainant and her son. There's body-worn camera footage that shows the complainant, an unknown male, adult male, and officer speaking during the initial call for service regarding the incident. The complainant stated that she wants to file criminal charges against the suspect teacher, and the officer completed an incident report. The case was referred to the district attorney's office and presented on November 1st of 2023. After a review of the facts, the assistant district attorney general declined to prosecute because the evidence presented to her was that the complainant's son was actively engaging in a fight. The incident report completed by the officer had the suspect's teacher's name spelled incorrectly, but that did not have any bearing on the decision-making of the ADA. And then the suspect teacher's name was correctly identified through further investigation. The suspect teacher was using, because they had a long name, was using like a derivative of their name. And so there was no mediation here. The investigative findings is that the complainant went to the West Precinct to file this complaint. She stated her son was assaulted by a substitute teacher. She wanted to press charges on the teacher and stated that the police report was inaccurate, and that she believed that that was the cause of the dismissal of charges. Because of the inaccuracy of the teacher's name, and that her son was actively engaging in this fight. Because there was no body-worn camera footage of the underlying incident itself, the investigation into the school altercation relied heavily on eyewitness testimony. The case was assigned to a youth services detective. Two adult women who work at the elementary school, the juvenile victim, and an unknown student and subject teacher were interviewed. Witness one, the teacher was interviewed. She stated that she was present that day, only saw the suspect with hands on the victim's shoulders, admitted she had her focus on another student. Witness two was the 10-year-old victim, interviewed on the same day, stated that he was involved in a fight on the playground, and the suspect came up behind him and put him in a headlock. He stated that he could breathe but had difficulty. He also stated that he tried to get away from the suspect but was held in a headlock for about 20 to 30 seconds. Witness three was an unknown student. That student stated that there was a fight and the suspect came up from behind and put the victim in a chokehold. And witness four was a teacher interviewed on the same day. She stated that when the fight began, she turned around and saw that the suspect was putting the victim in a chokehold. She stated she could remember telling him to let the child go more than once. And then also the suspect was interviewed at his home, is a full-time substitute, have worked with MNPS for about 8 years, and stated that during recess, fifth graders, they were having a fist fight. When he saw an opportunity to break it up, he decided to do that because he was concerned about the safety of everyone involved, that he came up behind the victim, placed his arm across the left shoulder of the victim, took his right hand and placed it on the right shoulder to steady himself, and then pulled the victim away from the fight. He admitted that his arm may have went up the chest of the victim child and caught him in the throat, but he denied that he put the victim in a chokehold. And so he said when he heard the teacher tell him to let the victim go, he did so immediately. He stated his involvement was only 10 to 11 seconds. In the NCRB's review, reviewing the timeline of events, there wasn't any body-worn camera, and other available evidence that was used to make the final determination. The investigation into the incident was assigned to Detective Tolsman of the Youth Services Department, Crimes Against Children. The review showed that the detective interviewed the eyewitnesses, the victim, and the subject teacher. There were emails between the MNPS employees and leadership, which shed additional light on the situation by revealing how many students were involved, the location of the incident, the alleged assault. The principal took swift action by placing the subject teacher on administrative leave the day after the incident occurred. The subject teacher at the time of the interview had not been back to school. And there was also, the principal also provided all the written witness statements from the teachers as well. The statement from the parent of the victim was included in the records from OPA, and she displayed her outrage and concern about how MNPS handled the incident because she was not notified and had no idea that her child was involved in a fight. The victim revealed that his shirt was ripped while in an altercation with another child. The subject officer at the time of the call for service did not have the complete name of the teacher and added to the report the name that the student gave him. The suspect used a short version of his name, and the incident report was later updated with his full name. And the ADA looked at all the evidence, reviewed the information, and made a determination based on the lack of evidence that an assault had occurred. NCRB notes that according to the investigation, there wasn't any video evidence captured on the playground fight or alleged assault of the child victim. And so the MNPD's OPA's conclusion in actions was for the violation of Manual 4.20.050, official obligations, false or inaccurate statements, was that exoneration. OPA did not provide a narrative for their conclusion and closed the complaint as a matter of record. So our conclusion, NCRB's conclusion, is the executive director reviewed the evidence in the case and concludes that the officer acted in compliance with MMPD policy and that OPA's investigation is complete and their findings are satisfactory. However, the NCRB's recommendation here is that that the executive director recommends that OPA always provide a narrative with their conclusions and determinations for closure of investigations. And so in my reasoning here is this. In this case, there was a thorough investigation conducted by Youth Services Division, the detective there, into an allegation of assault on a child. And this case, it's, in my opinion, any case connected with violence against a child and subject to such significant investigative work warrants more detailed findings beyond just a matter of record. Obviously, the detective from Youth Services spent a lot of time conducting his interviews, looking at the information from MMPS, as well as talking to all of these people involved. And so I would, providing narratives, explaining OPA's conclusions fosters public confidence in the police. It promotes the aims of transparency and accountability, and it ensures that the rights of involved officers are adequately protected, as well as what it does is if there's a separate category, for instance, it could have read that this case was closed, and it could have had some other type of addition to closure, like closed with the case was it didn't move forward with the ADA, or it may be a small explanation of why, especially involving a case where there's an alleged abuse of a child. And so that is my conclusion here, and I'll take any questions.
Okay, board members, anybody got a question, comment? No one?
I do.
Okay, Alicia had that.
Thank you, Chair Holloway. So on the violation or the alleged violation is that the report had false and inaccurate statements. So other than the substitute teacher's name being inaccurate, what were the main issues?
Yes. So what the mother was alleging was that her son was not actively involved in a fight. So she was saying that when they added that into the report, that he was actively engaged, that was false. What she stated was that he was trying to mediate the fight and break it up between other children. And then the other child grabbed him, and when he grabbed him, he ripped his shirt, and so he was defending himself. That was the inaccurate statement.
Any more questions or comments? Can I get a motion to accept? Okay, Heather, do you accept? Okay, so get a second. Second. Okay, that's been properly motion. Got a second. So, all in favor say aye.
Aye.
Anybody opposed? Okay, it passes. Thank you.
Thank you.
Go with the next one.
The next case is NCRB case CC 2024-024. The allegations of misconduct against Officer Pierce Moore. Number one, failure to provide medical assistance. Number two, deficient or inefficient performance of duties. Against Officer Daniel Rizzo, failure to provide medical assistance, deficient or inefficient performance of duties. Against FTO, Devin Hollingsworth, Number one, failure to provide medical assistance. Number two, deficient or inefficient performance of duties. The summary of the complaint allegations are such: on January 21st, 2024 at 3:30 a.m., Mr. Jesse Call, here and after referred to as the complainant, reported that he and Salvation Army staff made multiple 911 calls regarding an ongoing and deteriorating mental health emergency involving a Salvation Army resident, Miss J.V., here and after referred to as client. Mr. Call further stated that MMPD officers were slow to respond to the incident, that Officer Pierce Moore, here and after referred to as Officer 1, Officer Daniel Rizzo referred to as Officer 2, and later field training officer Devin Hollingsworth referred to as Officer 3, arrived, and Miss J.V. was in the middle of Stockwell Street, screaming and pacing back and forth. Complainant stated that he and staff made fresh requests for officers to have Miss J.V. medically assessed, but officers failed to assist. She was left without aid in 5-degree weather. That is the allegation. Policy violations are failure to provide medical attention, deficient or inefficient performance of duties, which is MMPD Manual 18.160.040, emergency assistance, and then MMPD Manual 4.20.050F, deficient or inefficient performance of duties. I'll skip the timeline. I reviewed the evidence that's in the report, and which was the investigation report, the CAD report, the body-worn camera for officers 1, 2, and 3, ECC transcripts, ECC CAD history report. Those were the main things that were reviewed. The findings of fact are such: on January 21st, 2024, at approximately 2:13 a.m., the complainant, who was a worker at the Salvation Army, contacted 911 to report that a client was experiencing an ongoing and deteriorating delusional episode while staying at the shelter. The client left the shelter location and was wandering into the street in 5-degree weather. The complainant and others were worried about her safety because of the temperature, the location, and her mental state. The client also contacted 911, and it was noted that she was screaming in the street, stating that someone raped her and or was attempting to rape other women at the shelter. Client left the shelter and was walking in and out of the street. The complainant and another worker were in the area sitting in a white truck, keeping an eye on the client until assistance arrived. Body-worn camera footage from officers 1 and 2 showed their arrival at or around 3:36 a.m. and engagement with the client. The client appears agitated, uses profanity when describing the conditions of the Salvation Army, and when officers try to engage with her, she is not interested because the Salvation Army called 911 on behalf of the client. The client refuses any assistance and walks away while talking loudly. The officer's interaction with the client is it's really less than 2 minutes. Officers 1 and 2 walk to the truck where the complainant and another worker are waiting and provide an update on the interaction. The officers state the client refused assistance, and the complainant is urging the officers to engage with the woman again, but they state that there isn't any more they can do to assist. The body-worn camera shows that the 3 officers are discussing the case but have no additional solutions, and the client is dressed appropriately for the weather conditions. Mediation was not offered. The OPA investigative findings, they revealed that the complainant initially reached out to Hub Nashville earlier on January the 22nd to file a complaint with OPA. The OPA reached out to the complainant on multiple occasions without any success, and during the same time, body-worn camera footage that matched some of the particulars of the call was found and reviewed. However, it could not be determined if it was indeed the same incident until there was a confirmation from the complainant. The complainant wasn't responding back. So on January 29th, 2024, Sergeant Woosley from the OPA closed the investigation as a matter of record because no contact was made with the complainant, but with every intention of reopening the case if contacted by the complainant and more information was gathered. On February the 14th, OPA investigator received an email regarding an update request from the complainant. On February the 15th, the complainant emailed OPA with the specifics of the incident. The complainant feels that the officers failed to render aid to a mentally ill client. The complainant works for the Salvation Army, was concerned for a female client that woke up in the facility screaming what he says was delusional claims. The fire department responded but did not transport the client, prompting the client to walk away from the Salvation Army. The complainant and his coworker followed the client in their vehicle as she walked down Dickerson Pike. The complainant claimed that the client was in the middle of the road yelling. On February the 16th, OPA found the pertinent body-worn camera footage for the alleged complainant and watched the incident. The body-worn camera footage showed Ms. JV standing near the sidewalk. The officers made contact with Ms. JV, who in turn yelled at them and walked away. As she walked away, officers asked if they could assist her, but she ignored them and continued to walk away. And so she was walking on the sidewalk, not in the roadway. I will mention that it was really a lot of snow and ice on the sidewalk at that moment. According to OPA, the officers approached the complainant and his coworker and correctly explained to them that they could not detain Ms. JV because the citizen did not violate the law or show signs of being harmful to herself or others. The citizen also refused assistance that was offered by the officers. Ms. JV did not meet the criteria for officers to take further action, which would have required them to physically detain her. According to OPA's investigation, officers did not detain the citizen because they did not meet the criteria that allowed them to. And based on TCA 33-6401, emergency detention, the only way officers are allowed to detain someone involuntarily is if they have a mental illness or serious emotional disturbance, and they pose an immediate substantial likelihood of serious harm, threaten homicide or violent behavior, or place others in reasonable fear of violent behavior, or if they're unable to avoid a severe impairment or injury that would likely cause harm. The NCRB's review of this case is such. In this case, the OP investigation showed the timeline of events. It also showed that the officers arrived on the scene at approximately 3:43 a.m. and engaged with Miss JV, who was standing on the sidewalk, which is covered in ice over snow. Officers asked Miss JV if she needed assistance. She replied loudly that the place, referring to the Salvation Army, was filthy and that men at the location were trying to FUCK the women who were residing there while they were sleeping. Officers again asked Ms. JV if she would like to go somewhere, and she states, if they called you here, meaning the Salvation Army employees, I don't have nothing else to say. And she began to walk away, mumbling to herself. Officers then walked to the parked truck where the complainant and coworker are waiting to discuss the interaction, and this lasted for approximately 2 minutes. The officer 3 arrives and is standing with the officers while they engage with the complainant and coworker who is in the driver's seat of the vehicle. The complainant wants the client to be taken somewhere to receive treatment for her mental health concerns and is concerned that she is outside in frigid weather. He explained her continued delusions and behavior and the possibility that she could be harmed by the weather conditions if she's left outside. The officers explained that there's nothing that they can do to assist her because she declined to engage with them by walking away and because she is not in an immediate danger to herself or others, and the law would not allow them to detain her. A review of the detailed ECC and CAD transcript shows that the Nashville Fire Department and Emergency Medical Service were notified and did, in fact, respond to the scene at approximately 2:15 a.m. However, the complainant, it was reported that the complainant, that medics refused to assist her, stating, "We don't chase people." That was in the CAD language, that the complainant said that. They were called to the scene by Ms. JV for leg pain, but upon arrival, the report states that she refused medical attention. Additionally, the body-worn camera footage showed that Ms. JV is clothed appropriately for the weather. She's wearing a coat, a hat, and like a hoodie. However, long-term exposure to frigid temperatures on that day could have placed her in danger, in my opinion. The conclusion, OPA's conclusion, is that they reviewed the body-worn camera footage of the incident. No policy violations were observed. And so for adherence to policies and rules, MMPD Manual 4.20.040, the recommendation is that it is unfounded. MMPD also, OPA's next policy violation was Manual 18.110.010, interviewing and transporting mentally ill persons. Their recommendation was that it was unfounded. The NCRB's conclusion is the executive director reviewed the evidence in the case and concludes that Officer 1, Officer 2, and Officer 3 were inefficient and deficient in their duties. OPA's investigation is not satisfactory and findings are incomplete. The NCRB's recommended action is that the executive director recommended that NCRB's complaint allegation of MMPD 18.160.040 emergency assistance unfounded. Additional recommendations is that executive director recommends that when allegations of assaults are made by citizens who may be experiencing a mental health crisis, that officers at a minimum confer with their supervisors for guidance as to how to handle those types of allegations and investigations. My recommendation is that MMPD should update or adopt a policy that aligns with the recommended action. In this case, continuing on, in this case, Ms. JV makes an allegation directly to respondent officers that some sort of attempted sexual assault occurred at the Salvation Army and stated this same allegation according to the investigation and evidence earlier that day. Although she may have been experiencing mental health crises, this serious allegation went unchecked by responding officers. The allegation was in the CAD reports multiple times and was not addressed by anyone on the scene. Ms. JV was clearly upset and agitated when officers arrived and stated clearly, almost immediately, that some sort of sexual misconduct had occurred at the location where she was residing. And although more information would have been necessary to conduct an investigation into Ms. JV's allegations, officers should have noted her concerns and, at the very least, contacted a supervisor for advisement on the scene, as well as referred the case to the appropriate division of MMPD for further investigation. It is noted that a field training officer, Officer Number 3, was on the scene but arrived after the contact with Ms. JV, but did not offer any specific guidance or helpful insight into this situation. Body-worn camera footage shows Officer 1, 2, and 3 standing around discussing the circumstances of this call for service for a while after the complainant left the scene. They mentioned another woman whom they stated was crazy and called her by name, had made similar allegations of being raped. The conversation related to this unknown woman I felt was inappropriate and disturbing. So number 2, the recommendation here is that MMPD should train their officers on handling sensitive allegations related to sexual assault. Additionally, officers could have offered Ms. JV cold weather shelter information. Although she walked away in her own volition, officers could have followed her and provided information that would have given her an option to stay in a safe, warm place instead of walking around in the frigid weather at 3:45 a.m. Because they did not offer any additional assistance to a person who was in crisis and left her in a vulnerable state to deal with the weather conditions, I find that they were inefficient and deficient in the performance of their duties. My recommendation here is MMPD should provide any persons who they encounter during severe cold weather conditions information on Metro's cold weather shelters and transport them if possible. That concludes my case, NCRB CC 2024-024. I'll take any questions.
Any question from the board? Okay, Sean?
I have a comment and a question. The first is just, I think this highlights the stigma placed upon people who are in mental health crisis and how they are, how they can be othered by anybody, whether it be the members of the public or the police, and how their words can be dismissed. So I just wanted to highlight that. And I think also my question is, was there any reason why Partners in Care or in the mental health the component of MMPD wasn't there? Because maybe they could have gotten a different response from Ms. JV.
Yeah, I don't know that yet. And then also, Partners in Care has certain hours, and that I think was outside of the time that they would work anyway. And
Okay.
they may not have been assigned to that area, because I'm not sure if they were in every precinct at that time. But I do know that the time that was reflected, Partners in Care would not have been working.
Okay, that's good to know.
Mm-hmm.
Thank you.
Okay, anybody? Mark?
Yeah, I
I have a couple of things. You mentioned another incident where officers were overheard talking about another similar case. Could you explain that?
Yeah, so when the officers were standing around talking, the FTO appeared and asked them, was it another woman's name? I won't mention the name. A woman that I guess had also made an allegation about some type of sexual assault or attempt assault at the Salvation Army. I guess she was a resident there and had been walking up and down the streets, and they were familiar with her. And so they were like, no, it wasn't her. He was like, man, she's crazy. And he was like, oh, I know who that is. Yeah, blah, blah, blah. And so I just thought it was very inappropriate to even mention this person's name in this conversation, especially if you hadn't even addressed her allegation at all. So.
Okay, so I had a couple of things I made note on this report. Delusional women can be raped.
That's right.
Let me just say that.
Absolutely.
Women with mental disorders, with personality disorders, they can be raped. As a matter of fact, they're easier targets for a rapist.
Right.
So let's get that out of the way. Second, you've got two now, allegations, be they false or true, about one service provider. And
That's right.
so now you've got another reason to be a little more suspicious.
Correct.
So and you mentioned what appropriate should be done. It should be referred to the sex crimes investigators. So take a look at it, because you never know, right?
You never know. Right.
The other thing is for the officer to write delusional claims in the report. So I've signed off on a lot of reports and written a lot myself, and that's just something that's just completely biased. You don't write that in a police report. Now, sometimes it's unintentional, and it's innocent, but bias, either way, intentional or unintentional, is dangerous in policing. You can't have it. It just doesn't work. You're denying someone their rights. So delusional claims, if he were pressed on that and put in court to testify to that, he'd have to explain his credentials for making that decision.
Absolutely.
So delusional or false claims are someone believes something that's not true, but even when you tell them that it's not true, they keep believing it, like, say, a politician losing an election. So that's delusional. That's delusional. So this has come up before with us. In the last year or so, we've seen reports of normal bias in police reporting. Mm-hmm. It's a normal thing. They're not bad people. They just write things that comes to their mind because it's human bias, right? So I'd like, just to put out this for conversation, I'd like for the board to take a careful look at the individual training curriculums for recruit, specialized and in-service training for the police department, with this in mind. Not the entire, we don't need all of the curriculum, all the copies of we don't need that. If we were to ask give us the topics that you're teaching, tell us the goal of each topic and the objectives of each topic. And I know they have them because you have to have a lesson plan for the state to recognize you're a post-certified trainer. So that's available. They've got that electronically. We can see it. And after we examine what's being trained in recruit or in service and specialized, then we can make a better assessment whether part of the problem of potential bias is training. And if it's true, then eventually down the road, we can take a look at recommendations. And I think this has been brought up before. IACP has a standalone policy on bias in policing. How do you prevent it? How do you recognize it? How do you correct it? The damage it does to the victims, the damage it does to the reputation of the police department, and on and on and on. And not to mention, the final thing here is liability. And this is exactly why Memphis has got a 12,000 class action lawsuit, person lawsuit against them over not testing rape kits because the victim didn't look like a rape victim. Mm-hmm. So there's a lot at play here. I mean, it's a simple report from a call to police. They did what they could, it seems to me, but there was more to be done. And I think we should learn from this so it doesn't, all of a sudden we look up and we've got some pattern somewhere and a station and a detail, who knows? You never know until you verify and check it. So my recommendation, and I'll I'll propose a motion to this, that we ask the police department to give us their curriculum, and let's take a look at it and see, are they training the prevention of confirmation bias or explicit bias or implicit bias, whatever you call it, so we can make a decision over a recommendation to the police department to consider a more advanced training in preventing gender bias, which it looks like it might be in this case. Sorry.
Okay, thank you.
Sure had it.
Yes. Well, I remember had it now. You Chair Holloway. I think. Somebody tell you was true. The problem that I have with this is that we're still talking about the zero tolerance sexual misconduct policy. And we now have a report or a complaint regarding the mental health and the of a member of the public at a facility, a well-known facility here, and the complaint has nothing to do with the sexual assault allegation that is lodged through this complaint. It's, you know, woven through it, and we're not talking about the fact that someone alleged that they had been sexually assaulted at a facility in Nashville, and MNPD did not investigate, they didn't acknowledge it. I mean, it was just a simple acknowledgement that a sexual assault had taken place. And for whatever reason, you know, the Partners in Care program, let's say it was funding, right? And they are not there at 3 o'clock in the morning or what have you. So we have two enormous issues in one complaint that we definitely need answers for. One, why are we not talking about an alleged sexual assault, right, in this complaint? And two, someone was having a mental health crisis and nothing was done about it. And so my question is, are we opening an investigation in the alleged sexual assault made by a member of the public? And two, what are we doing to expand resources in terms of mental health crises of members of the public in hours where Partners in Care, they are not operating? And great time, it's budget season. Will this be addressed during budget season, and can we anticipate more resources being put toward mental health services and resources at MENPD?
Sean, you have a question?
Yeah, okay, you're done.
I am done for right now.
I have two questions, and maybe Commander Laura can help us out here. One of the questions is, one of the questions is like now that this happened a year ago, we're talking about it now, we're talking about what our recommendations for moving forward if something like this were to happen again. But I'm thinking about, like, if this is, you talked about it being a well-known place where people seek refuge for help. So, like, I'm thinking about, like, if this is something that was happening a year ago, if it was happening, it could still very well be happening today. So is there some type of, what happens in those moments when something was not, when something was overlooked or not properly handled, but then here we are a year later, those things that were alleged could potentially still be happening? What's the police's response to that? And I have a different question after that.
Sure. So if you're asking what would we do if something occurred in the past and we believe it may still be occurring in the future later on, is that what you're asking?
Yeah, like, I mean, because it wasn't checked into at the time, we don't know if it was happening at all, of course, but we don't know that it wasn't happening. And here we are a year later talking about this unchecked thing. So, like, just in having this conversation, is that enough to even have MNPD just go and poke around just to make sure that the people are feeling safe in that space?
I mean, we can always, I believe we can always go and ask. I mean, there's nothing that's going to hurt us from going. And, we have our community coordinators and our, CET teams that go out there and interact with people in those areas. But we are not, we deal with, allegations of crime. So if somebody says, hey, this happened, our responsibility is to address that. For us to go in there and start now trying to find a crime that may have not occurred, I think is we've got to be very careful with that mindset, because now we're going in there and going, we're going to find something here. So I believe that if we're looking to assist people that may be a victim of a crime there, if we believe that, sending some of our resources like our CET teams, like our, asking Partners in Care to go out there and other organizations that we work with to go out there and, communicate, interact, talk to some of the people at these locations, then absolutely. And we've done that. We've been doing that in very often in different locations where we know that there's issues, and we'll send some of our resources out there and go, hey, just tell us what's going on. Is there anything that you want us, that we can help with? Sometimes people will tell us, yes, this is what's happening here in this location, and sometimes they don't want to talk to us. So we take it case by case, but we don't go out to try to find something if we don't have a specific reason to be there, I guess. I don't know if that clears mud.
Yeah.
Okay.
Second question. So because the Partners in Care, they're not operational at 3:45 or whatever time this occurred in the morning, does that information get relayed to them that like this particular incident happened, even though they're not being called at the time to do anything, but because a lot of times like people who may be unhoused, like seeking these resources at maybe the Mission or somewhere like that, they hang out in those spots all the time. So this person could very well be having another incident or another be in crisis again in that same area. So is that information relayed to Partners in Care? It's just like hey, this is a thing that happened. This may come up again.
So well, a lot of times we'll note, dispatch will note, hey, this person has had, specific issues that we want to make sure that if we come in contact with them again, we want to make sure that we address these, and we know that, hey, they've had a type of, mental health, episode, and we want to make sure that if we get in contact with this person again, we may want to have Partners in Care available. But we don't, there's certain information we don't just give out. Now, during the night times, we do have other health professionals that we can call the hospitals. We can call certain people that will help us at different organizations, like we can call one of the hospitals and go, hey, doctor, we have this going on right now, with this person. Sometimes they will say, bring them in to get checked out. Sometimes if it's not criminal and it's just they're having a very bad day, you kind of, our hands start to get a little bit tied, because if they're not committing a crime, there's no reason for us to take them, if they're not committing a crime, if they're not a threat to themselves or somebody else, there's very limited things that we can do. And so we have to take it, again, case by case. If we see that somebody's having a mental health breakdown, and we believe that they're a threat to themselves or to others, we deal with it one way. If they committed a crime, we deal with it one way. If they're just having a bad day and they're not doing anything that's illegal, we've also got to give them their space and give them the right, the ability to do what they have the legal right to do, even if we don't like it. And I think that sometimes is the hard part, because people go, well, why didn't you take them to jail? Well, they have the legal right. Just because they're screaming doesn't mean they're doing anything illegal, or just because they're acting a certain way doesn't mean that they're doing something that necessitates us to take them. So it can be a very tough, sometimes gray area for us to work in.
I just want to say, and I
Yes,
appreciate
ma'am.
that, because
Yes,
I
ma'am.
think that's accurate. I mean, if someone's having a mental psychosis, there's not much you can do. But I will say on this call, at the very moment that the call started, some of the language here is about the lady called about her legs hurting. That's initial call. And then it goes right into she's talking about someone raped her. And so this was something that was in this call throughout the call, that all, even if she didn't, at that moment, that she did not want to talk to officers, she clearly, immediately didn't feel safe enough to talk to them about it, because she felt like the people from the Salvation Army called them to assist her. Initially, when you watch the video, she's screaming out, the things that had happened at the Salvation Army. This is what she's saying. And then when they start asking her questions, she states, who sent you? Did they send you? Well, I ain't got nothing to say. and then she walks away. It's a very small amount of time between the interaction between this woman and the officers. And they say, well, what can we do to help you? And she starts talking loudly. It's not as if they went after her or tried to, to follow her down the street to see if she would be safe. There was no other interaction at that moment. So, yeah.
Yes, so, and to kind of tie it all together with Member Wynn's comments, Commander Laura, Edie Fitcher, Member Witzel, here we are with someone who's having a mental health crisis, and it's not like we want to give them their space just because, they've asked for it. They have alleged an actual assault, right? So this is not something that we would try to find or put on somebody, or, we're going in here and we're trying to, find a crime. She has stated, the victim has stated that something has happened. And so even if she is having a mental health crisis, I think it warrants some type of investigation or something that involves the acknowledgement of a sexual assault, especially if you have officers talking about someone else and an alleged sexual assault that they've mentioned, right? So now we have would that be a pattern? Was that what we would call a pattern, if it's two?
It could be, but it also may indicate there's myths and misconceptions about the validity of a rape report, which is very common in policing. Without data, for years, we assumed a lot of people were falsely claiming rape. When it was studied carefully, the numbers are at 2 to 8% of false reporting. And this could be a case where this woman's just making a false report. But you don't start by disbelieving.
Right.
You start by believing, and you want to look at, especially an institution that's dealing with people who are mentally disturbed.
That's right.
They could have staff that are taking advantage of that, and nobody wants that. So there may be a missed opportunity here for notification to the sex crimes investigator to say, just take a look. We have an allegation, we don't know, the woman wasn't cooperative, but she made the statement. That would have, to me, if I were the on-site supervisor, then I would have made sure that happened, and then instructions to the officer to be careful how they write the reports, because biased reports will stop an investigation. The detective reads it and says, oh, I've got another delusional person, I'm not spending my time on this, I'm moving on to something else.
That's right.
So these kind of things they just fall, and they start falling, you got a real mess in front of you. Not to say that this is happening here,
Right.
but this is what this board's set up for,
That's right.
to make sure that these kind of things don't happen.
That's right.
Let me say this, the whole incident may not have to do with the training. You get good training at the police academy, don't get me wrong. But sometimes when you get out in the field, you pick up bad habits. And then when you pick around, like just putting a rotten apple in a good barrel of fruit, it's gonna contaminate other apples. So this is what may have happened, and I put out training at the police academy with any police department. But it's interesting to see, whatever the case may be, you treat it as it is, If it feels like it might be a rape involved, you try to get some professional detectives or counsel out there to assist you, because you don't want to underlook anything. You want to be positive, because once you leave there, then something else could occur, which you probably could have prevented it. And see, you got counselors riding around with officers, but they got what you call a gravy shift. And a lot of your chronic illness thing occurred late at night, after 12, before 12. And there should be something like a call-out list. You can call someone that you can get in touch with to assist you. And see, that's how I see that. But concerning her case, her recommendation, what she made, what do y'all feel about her recommendation on her case?
Is the question whether they want to add to the recommendations? Are the recommendations satisfactory? I'm taking into consideration, do we want to take what, Member Nguyen said and add it to the recommendations? Because we can, the board recommendations are accept and send to MMPD, the chief of police and mayor, accept with modifications, or reject and send back to the staff for further, review.
Yeah, question.
Yes, thank you, Chair. I just, one, I had a comment. As a new member going through these review reports, I just want to acknowledge the comprehensive nature of these reports and how well laid out, and I imagine it took a lot of time for the staff and the board to do this, so I just wanted to acknowledge that. It's very impressive, and thank you for all the work you're putting into these reports. It's important. As far as the recommended actions, I have a question. We send these to the chief of police and the mayor. Then what happens to these recommended actions? Do we keep a list of what we're recommending? I think these are sound recommendations. I agree with the modifications that have been suggested. But what happens to them? Are they compiled in a list? Is this something you have conversations with the chief with? Or where do they go after they leave this board vote?
Yeah, that's something that we need to work through, but what I was going to do is do what we have in our legislation, and that is send it to him, and let him determine whether or not they want to make or move forward on any of these recommendations. One of the things that we've had in the past was a public-facing database that these went into. We also would keep up with, on that database, it would have these allegations, and then our review information, as well as the chief, the times that, not the times, but I think in our MOU, it says 45 days, right? That he has to respond to this, I think.
We were just discussing that, I think.
Yeah, I think it's 45 days. And once that 45 days comes back, we would put the chief's recommendation or his actions on that public-facing database as we had previously. And so that's how that goes. And we would hope that on some of these, that they could amend their policy or even have some updates. I don't know what they call them, roll call. What do they call them? Roll call trainings in how to handle these types of cases. My biggest concern with this case, one of the biggest ones, is that they did not seek any supervisor for additional information. And it was the FTO who was there to help provide assistance, but wasn't really helpful in that nature with the allegations. But when you're operating, as Mr. Nguyen said, from the perspective that the person that you're dealing with is delusional, instead of just listening and trying to take that information, and if the person is having some type of episode, it could be trauma, the residual effects of trauma from some type of harm that they had experienced. But sorry, I just went up into the deep end. But so yeah, we're going to send these to the chief and the mayor's office for the chief to weigh in and review them, and then determine whether these recommendations could be implemented.
Do we, go
I
ahead.
don't want to use the issue, two different things.
Yeah.
Yes, we do.
Make a decision on the resolution. The other, to me, is for the future, taking a look at if there's deficiencies, we should look at the curriculum for the police department and make recommendations based on what we're reading in the resolutions and how a correction could be made, just to offer a training, roll call training, full in-service training. But we don't know because we haven't seen the entire agency curriculum for all
Right.
All right.
So that was my,
Okay.
we can decide either way, but
Okay.
I didn't want to mix these
So
up.
we can I mean, we
So
can
there's
make,
no
you can do the recommendation, accept this as it is, we send it over, we can still ask for it's in the MOU, we can ask for all of the curriculum that's pertaining to this, and then review it, and then if you have further recommendations as it relates to the curriculum, then we can separate that from this right now,
I like separating.
right?
But not just related to this, all curriculums.
Right.
Because all curriculum should be trauma-informed and victim-centered, everything. So It could be everything they do, firearms, pursuit,
Well, we
interrogation.
have access to all the curriculum. And, you know, so we can get, like, what I could do for this, just so that for you, for the next, you can review this, send it to you to review as it relates to bias training.
Right.
And then if there's other things, I think, you know, that you want to look at as it, because you don't know what kind of cases are going to come up.
Right.
I think that you, you know, as we start getting it, so that you can review it and see if it is, if it can be strengthened.
Thank you.
Yeah.
Now, what do we have? Are we making a motion to accept your recommendation?
Yes.
Okay, now, do we?
Okay. Okay, go ahead and
Go ahead,
finish.
make a-
I was just going to say that sounds like a great topic for the training committee, and I make a motion to accept the chair's recommendation.
Okay. is there-
Second.
Okay, all in favor, say aye.
Aye.
Anybody opposed? All right, it passes. All right. It look like we down to new business. Do we have any new business at this time? Okay. Since we don't have a new business, I have one thing I need to get off my mind at this time. You said something about a computer problem.
Yes.
That's an expense.
Yes.
That need to go on your budget.
Yes, I've been having some computer issues, and
So
so,
we
yes.
need to update it or do something.
We need
you
to
know.
update it, yes.
That's
I don't
right.
know, I've been having some, yes, I was
So
having
we
some
don't need to
problems.
leave that kind of stuff out.
Right, because it did stop, it did hold up my progress, because I had to, some of them, we got disk, and then we also have flash drives. And the disk my machine wouldn't take the disk reader for some reason. It's just a lot, and it did hold up my progress. And when I'm in my mode, I'm just gonna tell you, when I've got my investigator's hat on, I'm, I don't like to be stopped and trying to fix the computer. I wanna get my information out.
Well,
But
we don't want to
just
do anything to
JK.
get you out of your mode. We want you to stay in your investigative position. But anyway, this meeting is, I believe we've covered everything on the agenda here tonight. And I'd like to appreciate everybody working with you. One thing I'm gonna do, I'm gonna make these pallets red, not green. I'm gonna be more alert. But anyway, no,
Okay, we can make it-
it's all in fun. It's all in fun, you know. But I've enjoyed the first meeting, and I've enjoyed working with everybody, and hope we can continue to move forward. Thank you.
Well, we thank you, Mr.
doing a good
Holloway, for
job.
running such a excellent meeting this evening.
We're doing a good job. The meeting, I can't get a motion to adjourn.
So moved.
Second.
All right, we adjourn. Thank you.
Thank you.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.